Welcome to another episode of the Trial Attorneys. I'm Shay Allen.
Ricky Granderson.
We're always happy to have you here. Remember, if you like what you see here, subscribe, YouTube, hit like. And always, while we're talking here, we're going to be talking about various issues. We like to hear what people want to say about it. So if you have comments, questions, go ahead and put those in the comment section, and we'll get back to you. Okay, so we're going to watch a couple of the videos here. First video we're going to watch is about a pretrial argument, or what we also call a motion.
I-R-A, I-M-A-H.
B-I-R-A.
I-M-A-H. So the way this came about was, we were looking at a different issue. The detectives yesterday afternoon sent an email to my co-counsel basically saying, hey, take a look at that report, this report that we're talking about.
Which detective?
In the attached.
Detective Flores. Flores? Flores. From Every Homicide?
Yes.
Go ahead.
So when this was received, my co-counsel looks and says, I've never seen this report. So he goes back in discovery, looks at emails, we don't have a report. So we instantly contact the defense, send them out the report. I want to be clear, the report is inculpatory, not exculpatory. So obviously, not only do we have no motivation to have not turned over this report, RHD has no motivation either. What's very clear is that they believe they had turned it over, and they did.
What time did Detective Flores bring this to either your attention or Mr. Pretrial's?
Yesterday afternoon, you want the exact time?
Approximately.
It was yesterday afternoon. We were in court. We went back to the office after court yesterday, and that's where we went back and looked to see, do we have this discovery?
So something after 4:30 p.m.?
The email is timestamped 3/18, but I got it when we, so it was essentially received but not gone through yet until I could get back over to my desk.
You conveyed this to the defense when?
We sent it to them at 5:21.
So about 40 minutes later, thereabouts?
Yes. Because the first thing we had to do was, we had to go back and see, or have we already turned this over? So we not only emailed it, we called them. We explained the situation. The response at the time that we gave it to them initially was, well, this is the same thing that you have accused us with respect to the witness in the court's file.
4 minutes have gone by so far, Ricky, and this is very important evidence, clearly, in the case.
The gun.
The gun, and it's more specifically ballistic.
You can use the ballistics of the gun or the bullet and see whether that bullet came from that gun.
How do you do that?
Because usually, with guns, they have what's called rifling.
Right.
And that means there are grooves inside the barrel of the gun. When you fire the gun, the bullet projectile goes down the barrel and basically is running up against the sides of the barrel and it's spinning like football. When they throw the football, it spins. That helps it go straight. And then these grooves are kind of embedded onto the bullet.
Right.
So, and each rifling has certain companies have certain type of rifling, like some twist to the left, some twist to the right, some of the grooves are closer together, some are further. And it's almost like a fingerprint.
Right.
Where you can say that bullet, if it's clear enough, came from that gun.
Absolutely. So this is why this is such pivotal evidence in a case where ASAP Rocky is accused of shooting someone. So if the alleged weapon was recovered, what they're trying to discover now, or trying to decide now, if the cartridges they recovered on scene, if they match the weapon that they recovered. Because if those two match, that's bad for ASAP Rocky.
Really bad.
That's very bad. So the other thing I noticed that's happening here, we're only 4 minutes into this pretrial argument. Seems as though the prosecutors just discovered this evidence yesterday.
I was just about to say, shouldn't this issue been addressed And a hearing on the admissibility of this way in advance of the day of the jury?
Usually, but the prosecutors, they're given timestamps. They're telling the judge, we just got this, yesterday afternoon at 3:00. And so, but the important thing they're saying is not only is this ballistics evidence, but it's further ballistics evidence in that the weapon that was fired, a Glock 43, is the groovings are even more particular than usual. So they're trying to add extra evidence that they just got the night before. If this happened to you, what would you?
I mean, if I was the defense attorney?
Yes.
I'll be rolling on the ground, foaming at the mouth.
Yes. Yeah. I mean, it's conniption time now.
Exactly.
I'm throwing things.
I'm performing for the television.
Yeah. This is. I mean, even when there's no TV here, I've gotten kicked out of courtrooms before. I mean, I'm rolling. You're right, because this is ridiculous. The night before,
I got kicked out of worse courtrooms.
Right. Yeah. Right. The night before.
That's horrible. It's embarrassing.
Yeah, and they say here's this evidence now. So we're getting into it further, but I'm sure the argument's going to get heated because if defense attorney, he's not going to want this evidence in the case.
Absolutely.
And quite frankly, it shouldn't be able to be allowed. Now, 9 times out of 10, what's the judge going to do?
Let it in.
Let it in. So
this is before jury selection, correct?
Yes.
So what's the significance of that? Would it have been a difference if the state says, oh, by the way, we have this after the jury's been selected and paneled?
Yeah, double jeopardy attaches.
Exactly.
Jeopardy attaches. If the jury's already in panel, now they can't go back and do it again.
Mm-hmm.
We've already started.
And if I were a judge in that situation, hey, that stuff's not coming in.
Right. Yep.
That they violated the court's discovery order. And we responded, no, this is completely different. You had interviews starting last August.
I don't want to get into who said what. I just want to know the sequence of events.
So at this point in time, we had a discussion. We sent an email at that point to counsel, and we included the court. There was an email sent late last night at some point by Mr. Tacopina. I did not see it until somewhere around 1, 2 in the morning. In that email, Mr. Tacopina cited the Hughes case. There were no facts in the Hughes case. I went to the middle of the night, I got the case, I read
I
it.
don't want to know about, this would be appropriate if you want to argue your position. I just wanted to know the sequence of events.
Right, I'm not gonna go any further other than to tell the court, I read the case, I then sent an email at roughly 3 or 4 in the morning. I sent it to counsel and I sent it to the court.
All right.
Can I have just one last factor on it,
Yes.
which is, I knew from past experience with firearm analysis that there would be a lab file or bench notes associated with the analysis. So I tried to immediately contact the lab to expedite and see if they could send that to me immediately, but they were not open at the time that I called. So we had to call this morning at around 6, and they scanned it and sent it over, and I sent that to the defense as soon as I got it.
How many pages is this report?
The
It's
report
ballistic.
is one
The
page.
report itself is
It's
one page.
One page. How many pages are there total of all the police reports, all of the discovery in this case? How many pages?
Regarding this harm,
Regarding the total number of,
regarding this one.
No, I
report.
was,
no, the total number of pages involving this case and this investigation.
I would estimate 100 or over 100 pages. I mean, to be totally candid with the court, I haven't counted them, but that's just ballparking the various reports, and things that we've received.
All right,
This is horrible.
You know what? First of all, in a high-profile case like this,
Yes.
as a prosecutor, and we're former prosecutors,
Right.
all the discovery, you're going to bait stamp it, right?
Yeah.
That means every piece of paper you can put a number. If it's 1,000 pieces, you're going to number 1 to 1,000,
Right.
and hand it to them, and they say, "Oh, I don't have this." Well, go to page number 537.
Right.
In a case like this. Secondly, I mean, he couldn't tell you how many pages it is. Secondly, when I was a prosecutor on a case like this, I always had an open file policy. counsel, if you look through your discovery, if there's something you need, call me.
Right.
I'm not hiding anything. Or I'm gonna sit down, go through the file. In a case like this, you got to do better.
Well,
You got to do better.
we want to put it out there. We were both prosecutors in a large city, Chicago. What are we, the second largest DA office in the country, or prosecutor's office in the country? And just to be fair, being a prosecutor is difficult. There are a lot of cases you get. There's a lot of evidence you have to try to marshal in the court. But on the other side, prosecutors have the ethical and legal obligation to make sure everything that they have, the other side has, and they have to do it immediately.
Well, and I'm not saying that it intentionally withheld anything.
Right.
But what I'm saying is, of course, they have a lot of cases, but you have a serious case that's on television.
Right.
You have to burn the midnight oil to make sure they can never point to you and say, this is missing.
Yeah, and you heard the prosecutors talking about some of those times. He said 1 in the morning, 3 in the morning. That's not normal, at least in my experience for prosecutors. For us, that's not that abnormal. So they seems like they did make the effort to get this over as soon as they could. But this, and then they call in the lab. I mean, when someone's freedom and liberty is at stake, these aren't the kind of things that should be done
At the last minute.
Now you can notice the defense attorney. I mean, he's almost in a pouncing position. I mean, he's ready. He can barely.
Oh, he's salivating. That's
Yeah,
what he's doing.
he can barely wait to just jump all over these prosecutors. The judge is asking appropriate questions, trying to figure out everything that's happening. But now, and just to be clear, we haven't seen this. This is our first time watching this video too, so because we want to get real reactions. But I think the judge still gonna let it in.
All my money is coming in.
Yeah. And remember, any questions or comments, put it in a comment on this. Do you think this is fair at this point in the trial for anybody?
Understand now the sequence of events. All right. Who wants to speak for the defense?
I think, I'll start. Maybe Mr. Siegel, if I leave something out, as we tackle this together. I mean, we spent literally the night before our opening, about 5 hours.
Okay. Speak slowly. The court reporter needs to get everything down, and I want everybody to know exactly what you have to say. Go ahead.
So, and I'll just stick with sort of the chronological order here. I'm not going to argue case law or anything like that, but aside from the fact that we lost 4 to 5 hours the night before our opening dealing with this, we this morning, after we get an expert report last night that was in the possession of the lead case detective in this case, not some random police officer. Detective Flores is the case detective in this case. I have to believe he understood the importance of that report. He testified at preliminary hearing. After we get that report that says, in conclusion, that the subcompact pistol frames, including but not limited to, which means absolutely nothing. So it could be a universe that we don't even understand of other pistols, and then goes on to list 3 of them here. This morning, we got another 28 pages of backup data on this. Backup lab, I guess, report that normally comes with a conclusion report. We got this morning. And I find it hard to believe that the lead detective in this case didn't bring it to anyone's attention from the district attorney's office until after a jury was impaneled the night before opening statements. I mean, something that they now are saying is such a crucial piece of evidence. We have an issue now with the jury. Obviously, it's a jury panel. It may affect, quite frankly, whether we would have kept or not kept a few jurors, one in particular. And we assured him yesterday he'd have a fair trial. You're going to have a fair trial. We've made issues regarding the veneer. You know that, Your Honor. I'm not going to rehash that. We're here. We're ready to open today. I don't even know how we're supposed to do this. This should be suppressed without question, because it changes the complexity of the case. At the very least, we have to quash this panel and start again. this is something that, you know, to render fair and effective representation here, as we all assured Mr. Mayor Stewart had, in the midst of a trial that's already underway, we would need to locate and retain our own expert to conduct a scientific analysis. Their report was 28 pages. It took them, according to them, it took them 1 week to do this. 1 week. And that's their own lab, with their own on-staff experts. And it took them a week. How long is it gonna take us? We have to go find somebody first, hope he's available, the trial will be over. We also have to make arrangements for the physical examination of the casings, scientific testing. I mean, if you look at their report, I mean, they cite like, some of the basis for their findings is the internet. They went on and cited all these websites.
Well, one, you can tell this is an East Coast, New York, Midwest type attorney in his confidence and I don't want to use the word aggressive. You could tell. You know, you can kind of tell attorneys who know what they're doing,
Right.
because they're comfortable maneuvering in the courtroom.
Right.
And you could tell that, you know,
Yeah.
versus this is in LA, right?
Yes.
Okay. LA is a more laid back kind of environment, right?
Yeah, I believe so.
And attorneys come off that way. And the whole issue, he can't have it both ways. If he's saying this stuff is crucial, I need to have our experts look at it, then you ask for a continuance. You know, that's the other option. He's
Yeah.
saying that it should be excluded in the trial. And that's well, hey, with option, hey, if you need more time, look at it.
Yeah.
But I mean, he has to do what he got to do.
That's true. But like you said, and I think earlier we said the jury's not out there, but the jury is in panel. So the juries, they pick the jury and they're getting ready to do opening statements, and then this happens. So I think what the defense attorney, of course, wants, he doesn't want that evidence to come in. And so a normal reaction, or a judge could say, okay, you can have a continuance. But quite frankly, as a defense attorney, you don't want the continuance. You just want it suppressed. You just don't
Exactly.
want. He said, well, they can't use it. But as we said many times, the judge he's gonna
Let it in.
He's gonna let it
Let
in.
the appellate court decide.
Right. Mm-hmm.
Which I think, I mean, do the right thing. That's just me. But some judges say, I let the appellate court decide.
Yeah. True.
I mean, there is so much work to be done here to even understand this conclusion. I mean,
All right, so what do you think?
what am I seeking?
What are you asking for?
Your Honor, I'm asking, well, and our letters laid it out, I don't need to rehash it, but our letters laid out pretty clearly what we're asking for. There's no way to proceed in this case if this is admitted. We have to either break this whole panel, we need a continuance, we have to start again. What I'm asking for is you include this. This is after the jury was impaneled. This is a major piece of evidence that will require us to do a lot of expert work. That took them, their own department, a week to do. That's the only thing I'm requesting. Short of that, Your Honor, I can't even open if this is coming in, because I have to deal with the address, I don't even understand it. And it's, we got, on the way to court, we have 28 pages of backup data. So that's what I'm requesting. I'm requesting this be included. It's after the jury's impaneled here. You know, Seal just pointed out, there's also a balancing argument under 352. You know, which I think is also something that's relevant here, including not limited to. But you know, we have this whole. I don't know what to say here, Your Honor. I really don't. I want to make sure he gets a fair trial. He's here, we're ready to go. We all assured him he'd get a fair trial, and this is, I've never seen anything like this. I'm not going to talk about the other witnesses, the late Brady disclosures, or the witness we got the name of for the first time last night. I'm not whining about that. I know that's what they want to keep doing. We both have had issues with that. That's fine. I will not make it an issue of it anymore. You've already ruled on that. Period, end of story. This is now a new one. You know, I don't want to get into, I told you so, but many people said to me this morning, I told you so, that this was going to happen. And I'm trying to keep my composure, Your Honor. I don't know if I've ever been this upset in a courtroom. In my whole career, both as a prosecutor and a defense attorney, I have to be honest with you, this is not right, it's not fair to him.
May we respond, Your Honor?
Hold on. Mr. Siegel, do you want to?
Yeah, the only thing I wanted to say.
I don't want you to repeat what Mr. Tacopina said. You want to add something new?
No, but yes,
You're welcome to it.
I want to add something new.
Go ahead.
Dovetail what he said with respect to the 352 arguments, and that is the report says that the characteristics include are not limited to certain firearms. That means the universe of firearms in this case, based on the face of that report, is extensively broad. So given that, Your Honor, I think even just the probative value of this is substantially outweighed by the danger of undue prejudice, separate and apart from the late disclosure. So it should be excluded on 352. But that's secondary to the fact that it's just incredibly late at this stage for all the reasons Mr. Tacopina said. So I'm just adding that additional factor.
All right, what I'm hearing from you then, it seems like you're talking out of both sides of your mouth. The defense is like, it's irrelevant. However,
Like I said, we're watching this for the first time, and just that you said exactly, the judge said exactly what you said, Ricky, talking out both sides of your mouth. Which one do you want? Can't have it both ways. So now, what's also funny here, we notice here, you know, you never want to do a jury trial by yourself. So
Exactly.
there's several attorneys over there with ASAP Rocky.
It looks like an assistant to maybe a young attorney, the young female.
Yeah, yeah. So and I think I see another, a fourth one over there in the corner as well. But that's usually how it works. Kind of, you know, one attorney may be there's going to be a lead. That means a head attorney generically, but the kind of the rah-rah guy, you know, the angry, you know.
That's you.
Yeah. and then there's a law guy.
That's me.
Yeah, you know, right. There's a law guy that, you know, when May says, okay, you know, you got screamed at, but then this is the law, you know, we're looking at.
Good lawyer, bad lawyer.
Right. Good lawyer, bad lawyer. So, but the judge, he said exactly what you said. You know, what do you want? Is it relevant or it's not?
Exactly. I have a question. He said that the jury has been impaneled and this issue comes up. Does jeopardy attach?
Yes. Yeah, jeopardy is attached because the jury's impaneled.
Other words, that because they've been impaneled, it's basically the trial has started.
Yep, the trial has started.
So you can't, in the middle of a trial or any part of the trial, say, "Hey, by the way, we have this."
Yes, I know.
And if you do this, you can't retrial.
I mean, this is devastating. This is devastating for.
Sometimes you want to say you'd rather say to the prosecutor, "Just give it to him." I don't want to have to do this again, and it's gonna make me look bad.
Yeah, this is devastating evidence. I mean, to pull out right after the jury's picked. I mean, before you even do opening statements, I agree with the ASAP's lead attorney there. Or it seems to be the lead attorney. I agree with him in that. I would be very upset.
He's not rolling on the ground like we would.
Oh yeah, yeah. It's true. It's true. You know, he's doing a good job.
He's doing
keeping
excellent
his
job.
composure.
I still don't like the tan suit.
it's so prejudicial that it shouldn't be allowed in. It's so inculpatory that it shouldn't be allowed in.
No, I don't think anyone said it's so inculpatory. We don't understand. Saying it's inculpatory is not accurate. No, I didn't say it's inculpatory. He didn't say it. What he said was there's a balancing test because it says including but not limited to. All that simply means is not that it's not inculpatory, not that we just don't understand what this means. Not limited to means there's a universe of guns that have to be tested now. I don't know what not limited to means. So how many pistols does not limited to include? How many firearms does not limited to include? That's what it means.
Okay, who wants to speak to the people? Go ahead, Mr. Young.
I want to take things one step at a time. Counsel brought up and made a comparison to what has happened thus far.
Just a minute. Alex, could you please go out and tell the jurors that we're dealing with some logistical matters, and just please be patient, and we're going to have them come in as soon as possible.
Yes, sir.
Go ahead.
One, as the court is aware, there is no logical reason why either Robert Hamadai's division or the DA's office would have in any way not turned this over. It's very clear that this evidence only helps our case. Although again, as the court pointed out, on the one hand, Mr. Tacopina says, the client cannot get a fair trial. This is so apparently damaging. Yet on the other hand, he says, hey, it doesn't really matter because it includes so many other guns that it should be kept out as being irrelevant. But what's very clear is, and I didn't appreciate the comment, when Mr. Tacopina suggests that he can't believe that the DA's office did not know about this in advance, when I spoke to him on the phone last night, that is not what I heard. What I heard was, say, listen, this is a problem for us. We understand, I'm gonna quote Mr. Siegel.
Uh-oh. The prosecutor is starting to talk about that conversation on the phone.
You know what? Here's the thing. One, first of all, I had that is the attorney who represented Stormy Daniels, and Donald Trump had a point because he told his name. But when you get up there and then you kind of, I think he said that the judge didn't know what he was talking about or something like that. He made a comment. You can't do that. When you win, and don't attack be disrespectful. He has that New York kind of aggressive. But, you know, I had a case down in Southern Illinois, and I knew that I could not conduct myself the same way as I was in Chicago. Because
Right.
I don't have home field advantage.
Right.
So, you know what I'm saying? But you always have to maintain. He did a great job. His arguments are good, but you still have to maintain, oh, I'm a victim. You
Right.
know, so we're a victim. And the state, I mean, sometimes you have to kind of confess error and say, but judge, he has this opportunity to, we made every step to correct it.
Sure.
And if it's that serious to him, you know, he can ask for continuance, or don't start the jury for 2 days and you get 2 days and look at your experts, whatever. So sometimes you have to confess your sins and move forward.
So the attorney is Joe Tacopina?
That's him.
Tacopina, that's his name. But he's, you know, doing a great job so
Yeah.
far. But, and like I said, it's the first time we've watched this, so we're getting our, you know, reactions, first time seeing it. But the reason I stopped it there is because I predict it's going to start to get nasty.
Yeah.
Because the prosecutor's now saying, well, that's not what the defense attorney said on the phone last night. You don't, you know, that's not a way you want to go with the argument. You don't want to start making that route when you're making an argument in court.
Either you presented it in a timely fashion, if you didn't, what's the proper resolution?
Yeah.
Don't get into, well, we said this and he said that. You know, the schoolyard type thing. It doesn't help you because you're the one that looks bad.
Right. It does.
And to turn around and say he looks bad, that's not a good way to go forward.
No, because if you as an attorney feel as though you can't have an open conversation with a colleague, opposing counsel on a case, then that takes away from that attorney's, I think, integrity as an attorney. I mean, of course, this attorney, I think he's based out of New York.
Oh, absolutely.
So he's probably
Bring
not
a New York accent.
Right. He's probably not going to be back here often, but still, I don't think it's something that the prosecutor, you don't get into what you guys talked about on the phone. I don't know, that's strange.
Yeah, there's no reason why you would have not turned this over if you hadn't, which is correct, and the record would support it. Comparing this, counsel is now discussing and saying how they are being victimized by late discovery. The only late discovery in this case, and the court's aware of it, the court ordered that the discovery be turned over on 2 witnesses. It should have been turned over before the court ordered it.
I don't want to deal with something that we've already dealt
Okay.
with. I understand about the 2 defense witnesses. We've covered that.
Right.
Just deal with the present issue.
So, what counsel did is, he cited last night, he sent to the court a case called Hughes, 2020 case, 50 Cal at 5th at 257. He included no facts about that case. At 2 in the morning, I went and I read the case, and I then sent an email. That case, so the record is clear, involved a situation where there was a Watson murder, and where the defendant was being tried on a theory that his alcohol intoxication had caused the accident. Investigation had been done by the MATE team, and they had determined that in fact it was speed and not alcohol. This was a very huge problem for the prosecution because that was the theory of their case. apparently the head of the MAID team started redoing a separate investigation, which the evidence suggests the prosecutor was well aware of. At the very least, and as the Court of Appeals said, the prosecutor was given information that in fact the MAID lead detective now had a new opinion contradicting the prior opinion that in fact, in actuality, it was caused by alcohol and not by speed. Instead of turning this over to the defense, the prosecutor literally had the witness on the stand in front of the jury. He then pauses, looks over at the defense and says, hey, by the way, here's the diagrams and here's the information that he's going to be testifying to. Defense is obviously horrified because it's the entire case. The defense asked for a mistrial. They asked for a continuance. They were both overruled. The Court of Appeals said, hey, listen, obviously the suppression of evidence, as the court is aware and under the statute, is the last option a court can utilize, only after every other option has been determined to be not harsh enough or not accurate enough in addressing and solving the situation. Court of Appeals said, hey, listen, Judge, you had a chance to do less remedy, you didn't do it. The jury ended up convicting and the case was reversed. To compare that case to the facts of this case, it is distinguishable for the following. Number one, that evidence was not just inculpatory, it was the entire case. Number two, the prosecutor, for a tactical advantage, which the Court of Appeal basically said in a footnote, that although the original trial judge had found no prosecutorial misconduct, that in essence the record didn't support it, meaning that there was misconduct that the prosecutor did. The prosecutor decided, for a tactical advantage, that he was not going to turn it over. He then did it while the witness was on the stand. He then opposed any continuance or mistrial. Here's what we have. We have evidence, which it is inculpatory. It's inculpatory because the defendant is found at his location, at his house. There is a 9mm magazine for a Glock 43, and there's no Glock 43 to go with it. So it's just a magazine. We already knew that the defendant had the Glock 43 magazine, and we knew that these were 9mm casings. The difference now is that there's going to be evidence that suggests that a Glock 43 is more likely to have put the marks on the expended casings than many other firearms. So the idea that this would be excluded under 352 is patently absurd. The idea that Hughes is in any way authority for what they're asking is also absurd. We talked to the lab this morning. First, what we are proposing is that we will not mention this evidence in this case in opening. We will wait and see how the case develops. As the court is aware, and the court is aware of this from the discovery of the witnesses that we got the day before we started trial.
I think it's absolutely stupefying what he just said.
Yes.
You know, that, oh, you're making a big deal out of this.
Of course you're making a big deal. This is very important.
He's looking at him like, dude, what are you making a big deal out of?
Come on.
Like the fact that in the case that he cited, and it was reversed, that they gave him the evidence after the witness testified.
During the witness.
Okay.
Yes.
But that doesn't make it good that you give it to him after the jury's been impaneled.
Same, yep.
It's
Same
the
effect.
same thing.
Same effect.
It's like saying, well, I shot you 5 times.
Right.
Oh, that's horrible. Mm-hmm. But if I shoot you twice, that's not as bad.
Yeah.
But you shot him.
Yeah.
I think it's, to say it's absurd is absurd.
Well, this is the job of the judge. A lot of times attorneys use words, absurd and ridiculous, and this is, but I was always taught to not use words like that. Make sure that your argument is such that you don't have to use words like clearly and, to be sure, those type of things.
Those are conclusions.
Those are conclusions. Make the argument so strong that it is clear. Make your words so powerful that it does sound ridiculous or absurd. But when you say it's absurd, then what was the point of you saying everything else? You just say it's absurd and stop.
It's like cross-examining a witness. You don't just call him a liar.
Yeah.
You make his answers, the questions you ask, force him to give answers that make him look like a liar.
Yeah. And the other thing, too, if I'm a judge and an attorney says something like the prosecutor just said. Now, the prosecutor's argument was lucid. It made sense, for his perspective in that regard. It was a well-formulated argument in that regard. But if I'm a judge and I hear attorneys say the other attorney's argument is ridiculous, then I'm tuning him out.
Exactly.
He's doing his job. He's making an argument that he believes is valid. You don't have to call it ridiculous. Just you don't agree with it.
But at the same time, it's not absurd.
It's not.
It's like you give him this evidence after the jury has been in panel, and he's complaining about it. That's not when you use the word absurd.
No, because this evidence is horrible. They found, as it just said, they found the magazine in ASAP Rocky's residence allegedly, but they didn't find the Glock 43. So they have the magazine, and these cartridges or shell casings are going to match the bullets in that magazine.
But here's the thing. I know he's doing his job, but really that doesn't hurt him. You know why?
Why?
Because first you're going to have this one lab that says it was another type of gun.
Right.
Then you're going to have this type of gun. That shows they don't know what the hell they're doing.
That's true.
That's
true.
reasonable doubt.
Yeah.
And when did they do the second test? You see what I'm saying?
Yeah.
You did this test when it's closer to the crime, and conveniently also, and he says it's likely. What is likely? What does that mean?
Reasonable doubt.
Reasonable doubt.
Reasonable doubt. That's what
So
it means.
it
to me.
doesn't really, in reality, I know White's making the argument. In reality, you can impeach the heck out of them.
Right.
And in closing arguments, throw it back in their face.
Exactly. And it was funny at the end. He says, "Well, hey, we'll wait until our lab, looks at this, and then we'll wait to use the evidence. Thanks a lot."
Thanks for the favor, dude.
The defense is now claiming not only that it was a starter pistol, but they are claiming that the 9mm magazine, which was found at the defendant's residence, actually belonged to the defendant's manager, and that he is going to testify. So let's look at how this plays out. If the defense ends up being that, in fact, this 9mm magazine belongs to the manager, that in fact what was used at the scene was a starter pistol / prop gun, then although we don't believe that's credible evidence, that is where they're going. So here's what we're asking. One, there's no late discovery instruction, because as the court is aware, and maybe counsel is not, to have a late discovery instruction, the court has to find.
Oh, he's insulting him now.
Here's the thing.
Uh-oh.
Here's the thing. You represent the people of the state of California.
Right.
Okay. You are going to be held, to me, at a higher standard even than defense attorneys, because you represent everyone.
Yes.
To get into this, always maintain your professionalism.
Absolutely.
And we've experienced where jurors, if they didn't like the prosecutor, it was a not guilty.
Yeah. It's true.
If they didn't like the defendant or the defense attorney, it could be a guilty.
Yep.
But never give them, and he's making these comments about, well, they're going to call this witness and that. You don't know who they're going to call. Mm-hmm. They don't have the burden of proof. They can decide the last minute, I'm not going to call them.
Yeah.
So you're just giving these hypotheticals.
Right. And he says to him, or maybe defense attorney doesn't know this.
Oh my God,
Why
don't
are
do
you
that.
insulting
Don't
him?
do that. Don't do that.
Well, and sometimes I think a lot of times the prosecutors, they can get too personal. Remember, we were called hired thugs. One time in
Yeah.
the closing argument?
I did roll on the floor at that time. Yeah, in a closing argument.
Yeah.
And the judge, who I didn't think liked us, he was so upset and warned him never to do it again.
Right. Yeah, that was completely, and of course we won. Well, not of course, but we won that trial very quickly too, and it was a tough case. But yeah, we were called hired thugs.
Thugs or something. And he pointed to us.
Yeah.
And I looked. I said, "Did this dude actually call us?" I mean, I've called worse, but I mean,
Yeah.
come on.
Well,
That we had the information and didn't turn it over. There's no reason why we wouldn't have turned it over, and as soon as we had it, we turned it over. And as the court's aware, I've been trying cases in front of His Honor for going on 30 years. As soon as we found this evidence, we contacted the court and we contacted counsel. Number two, the lab has told us that basically what they did in this case, to have someone else examine it is a very quick examination. And the amount of time that it should take for someone to examine it and end up being able to assess whether or not LAPD was accurate in what they found is ranging from a few hours to maybe a day. This is what we would propose. We would propose that at this point in time, we will not mention this in opening statement. We will see how the case develops. We will, if we believe that this is evidence that is going to be important, we will ask to admit that evidence later on in the trial. In the meantime, we will make arrangements for counsel, and they can hire any qualified firearms expert. I want to distinguish between Hughes and this case. Hughes was an extremely complicated accident reconstruction involving a vehicle where multiple individuals died. It was very time consuming. It's an extremely complex investigation. This is very minor and simple ballistics interpretation. So we will make it available. We already have sent our investigators to recover the evidence. I don't know if they already have it.
I believe they've already.
We believe they already have the evidence, they have it with them, and we will get it to the defense. And I just, this is related to the other issue, so I just want to make sure that this is clear. Counsel seems to be under the impression that the court has now changed its ruling and that we are not allowed in our opening statement to address the idea, which the court previously ruled we could, that we did not find out about this defense until the 20th. The court had said previously, on the record, yes, Mr. Lewin, you guys can address that issue in opening. I will decide whether I'm going to issue a discovery instruction later. Counsel believes you've now said we can't do that.
I did say that.
Yes, they did. Yeah,
I
pretty
did.
clearly.
I had said yesterday that the purpose for an opening statement is to give the jury an idea of what the evidence, what you believe the evidence will show. Talking about late discovery, that's argument. So as far as your opening statement, I don't want you to mention anything about, you just found out about a starter pistol. That is not part of what the evidence will disclose. I talked about that yesterday.
So but I am correct, the court's original ruling was.
Yeah, that is what I said. Originally, I said, yes, you can bring it up.
Okay.
But then after thinking about it, that's not part of an opening statement, so I don't want you touching it.
Okay, understood.
Go on with the present issue about the ballistic.
So where we sit right now is that counsel is arguing two inconsistent positions. They're arguing that this evidence is so damaging that we have to start over. Now, that's not in a vacuum. It's very clear that the defense is not happy with this jury. They've made it clear.
Hold on.
No,
Oh,
don't
I'm
interrupt.
sorry. Okay.
He didn't interrupt you, don't interrupt him.
It is
Go
very
ahead.
clear by the comments the defense has made in court, where they have repeatedly said that their client is not getting a fair trial because of what they believe is the composition of the jury, the fact that they have filed a writ, the fact that they have continued to bring this up. leads to the inescapable conclusion that what they are looking for is a way to start over. I believe, Your Honor, that what we have proposed is more than fair.
Respond to that.
Well, again, the prosecutor is really, I think he's trying to put words into the defense attorney's mouth, which is a mistake. I think it's important for defense attorneys to complain about jury makeup.
That's
how
his
juries
job.
Look. Yeah, that's what he's supposed to do. So I don't know why the prosecutor is taking that approach in regards to his arguments and what he thinks the defense wants or not in that regard. It's not a argument I think is strong, an argument I will make. It doesn't seem like the judge is really, filling that argument generically.
Another thing is, you're saying that while you're sitting there, basically accused of holding back really important evidence.
Right.
And you try to run away from that by saying, well, the real reason why is dude, even if that's not a reason,
Right.
before you is the fact that crucial evidence you didn't turn over until the jury was in panel. It's like a bait and switch.
Right.
It doesn't matter. He may have multiple reasons.
Mm-hmm.
So I don't know why he is focusing on. He doesn't know what he's thinking. He doesn't know why he's doing certain things. And even if he wants to, he has the right to do that. That has nothing to do with whether you, in a timely fashion, provided by law and statute evidence to him.
Yeah,
And it makes you look bad.
The
And I
prosecutor
I'm
keeps
sorry.
going back. He keeps going back to other arguments, other issues that come up. The judge rightfully so says, look, okay, we've dealt with that. Now focus on the point at hand here. You turning over this evidence at the last second. That's what we're talking about.
And the judge is good in the sense that even though it's almost kind of a personal attack, he's made sure the defense attorney stay professional. It's not about that.
Right.
And he focused on him. But to me, that's an admission that he knows the prosecutor knows he's in trouble. He has to talk about everything but what the real issue is.
Yeah, except the actual issue.
What the actual issue is.
As the court mentioned before I ever pointed out, they're arguing, if you let this in, Judge, my client can't get a fair trial. Oh, by the way, what's the value of this anyway? What does it matter? Again, my position would be the second argument is inaccurate. It is evidence that is helpful to our case. It doesn't prove the case by itself, but it is definitely helpful. It is not irrelevant. It's not 352.
All right, you don't have to go on.
Okay.
I believe I have enough information to make a decision.
All right, you heard, please. On
No,
the-
no, you can't.
I can't respond to what he just said about the jury.
It doesn't matter about what he said about the jury. That has
No, it
no,
doesn't.
stop.
Come on.
That has no bearing on any decision I'm gonna make.
There's a record, though. There was a record, right? Okay, place something.
I don't believe that you are unhappy with the jury.
I'm
Mr.
not.
Lewin might say you're unhappy with the jury, but that's not, I don't believe you are. If you were, you wouldn't have accepted the jury. I believe that both sides are satisfied with this jury and that both sides will get a fair trial. You don't need to respond to it because it doesn't matter whether he does or does not think you're happy with the jury. I believe that you are satisfied with the jury. All right, here's the way I want to deal with the latest, this recently finding.
The judge did a great job right
Oh,
there.
he's absolutely in control of his courtroom.
Fantastic job.
Absolutely. I wish they had more judges like that.
Yep, he made it clear. I mean, he kind of guessed what the defense attorney was upset about and made it clear. I don't care about what he said. And it almost said it in a way, what the prosecutor said was silly. Doesn't make sense to him. So you don't have to, I understand, you don't have to make the argument because I understand it doesn't make sense to me. It's not going to affect my ruling. I understand.
And he's checking both sides.
Right.
He's doing it to both sides.
Yep.
And I think he sensed that New York performance attorney was coming out. He says, "No, I'm stopping you right there, dude. That's not necessary. I know what the issue is.
Right.
You don't have to perform. You don't have to respond. Because it's really is irrelevant."
Right. Great job.
Out about this ballistic report. Everybody at the table, all counsel, to me, has great credibility. I accept what all of you say. I don't believe that there's been any nefarious conduct by anybody. If this late report involved, all of a sudden, it was disclosed that a witness, an additional witness positively identified Mr. Mayers as the shooter. That would be very critical and crucial. If a witness came forward and said, yeah, Mr. Mayers confessed to me that he shot ASAP Rowan, that would be very critical and crucial. If a firearm, if a 9mm was recovered, that could be ballistically compared to the casings, and that just became discoverable or became disclosed, I think that would be critical. But that is not what happened here. What I'm seeing here is that the casings that were recovered were examined, and the opinion is they could have been fired from a Glock 43 or any other number of types of 9mm. You have said that, well, now you have to hire, you want to hire a ballistic expert. That's not fair to you and your client. So this is what I am proposing. We have a list, a Superior Court list of firearm examiners that have been recognized as experts. My star judicial assistant over there, Alice, will print out that list. Ms. Kaplan is an attorney who practices in this area. If there is someone on the list that you want to hire, contact that person and tell them this is crucial that the ballistic evidence be examined now, not later, but now. The court will pay for it. Mr. Mayers will not have to pay for this. We will. If the firearms examiner wants extra money because it's a rush, the court will pay for it. If you are not satisfied with the people on the list, then if you want to find your own examiner who will do the examination, the court will pay for it. If it's necessary that I speak to the examiner to impress upon the examiner the importance of getting this done ASAP, I'm glad to do that. I am providing.
I'm shocked.
I'm stupefied.
I am shocked.
This is such a great judge.
Oh my goodness.
I think he's so neutral and detached.
Yes.
Maybe cameras in the courtroom that cause other judges to be like that.
I never had this happen. Well, we'll pay for it. We understand this. You know, he's not saying, oh, you can afford it, you pay for it, or figure it out. Wow, he said the court will pay for whoever you want. We got a list first, and then after that, the court will pay for whoever you want.
Well, and another thing is, technically, you know, if you don't ask for something that you might get, because you don't know what his results are going to be.
Yeah, that's true.
You know what I mean?
Mm-hmm. That's true. Yeah.
I mean, it's different when you come from a list of court-appointed experts versus you use an expert that you've used before.
Well, yeah, that's very true. This, you know, this court-appointed list, this attorney's probably never worked with these folk in particular.
You know, he's working. He's probably not like. I don't think he's licensed in L.A. I think that's why he has these other attorneys.
Yes, California
so
attorneys, yeah.
my point is, these court appointed. Those are the ones. You know, when you have to. You know, the defense has an expert and the state has an expert. Right. Sometimes the court has an expert. Right. That's to show that that one is neutral. Mm-hmm. If you're asking for this exam,
right?
I think it's better just to, hey, let it on in and impeach the hell out of them.
Right, ask the questions, because so what you're, in essence, what you're saying is if another expert looks at it and it is the same as what the prosecutor's expert is saying, now you have to turn that over.
Or more incriminating.
Right, that's
or
true.
more incriminating.
Mm-hmm, it's true.
So if you're going to ask for it, you don't.
Be careful what you ask for.
I couldn't think of careful what you ask for.
My cell phone number to all of you. If you need to call me any time of the day or night, I will speak to you. I will speak to a firearms examiner. If you feel it is necessary, Mr. Tacopina, we can be dark on Monday. But I'm not excluding the evidence. I don't find that there is any nefarious conduct. the evidence is relevant. It's not a smoking gun, but it is somewhat inculpatory. But it in and of itself does not mean that your client is guilty. That's the way.
You know, the more I hear about it, you know, it is clearly unfair. It's clearly came at the last second, but I don't know how inculpatory it is.
I don't think, I mean, I think he did a good job of balancing it. I mean, he said this is not a identification evidence,
Right.
or someone say he admitted it.
Right.
So, I mean, I don't think the defense really is me totally. I know he has to do his job, but I don't think, you know, you have to stand up there and say, oh, well, his rights have been violated in fair trial. But you could impeach the heck out of these guys with that.
Yeah, exactly.